Well, these are serious charges, charges of terrorism, murder, conspiracy to the formation of terrorism group and being a member to a terrorism organization, terrorist organization, and a lot of crimes the organization, which is the FLN, is responsible for having committed in Rwanda. So those are serious charges, and they are in the category of cross-border crimes.
So we've seen reports talking about the credibility of Rwanda's jurisdiction, or if he has to be charged, his cases, he has to be charged in the Rwandan courts. What do you make of those reports? What do you make of those allegations, despite the crimes being committed on the Rwandan territory?
Well, the credibility, I think, of the Rwandan judiciary is undisputable, because we have had cases transferred from ICTR, as the former International Criminal Tribunal for Rwanda. We have cases transferred from Europe and other places. And these cases, to reach the level of being transferred to Rwanda, is that they had gone through a rigorous judicial process to attest to the independence and impartiality of the Rwanda's judicial system, including having had some cases go up to the European Court of Human Rights. So that is, I think, an issue that has already been litigated. Of course, people in defense will always bring it up, especially from the Western media, but I think in terms of judicial independence, there is no doubt about that.
So what we've seen today, the pre-trial hearing has started. What do you think is going to follow next?
Today they were in a session of whether he can be tried
at Kicukiro Primary Court?
Yes, whether he can be tried when he's not in detention.
Yeah.
So it's a process, because as a matter of principle, based on the presumption of innocence, any person who is accused of a crime is supposed to be presumed innocent, and you should be tried when you're not in custody, in detention. But because of maybe there is a fear of flight of justice, or obstructing justice, destroying evidence, and when there is good evidence that the person that is suspected of the crime might have committed those crimes, the court can allow that person be prosecuted while in preventive detention. So it is today, after that, whether they have decided that the procedure continues when he's in detention or not, the next step is for the prosecution to consolidate the evidence, make the file, and then take the case to court for substantive trial.
So we've seen Rusesabagina also apologize for the crimes that were committed by FLN. What does that mean in terms of the number, the sentence that is, supposed to receive, if any? What does that mean in this case altogether?
Well, I don't know to what extent, because I don't think he has pleaded guilty, because if someone is charged of a crime, you might, as a matter of sympathy, express that you feel sorry for what happened. But then when you add on to say that, but I'm not responsible for what happened, then you have not pleaded guilty. You simply expressed your humane.
So what happened is that he admits that among the responsibilities he sent FLN to do, he did not tell them to kill citizens. So he probably told them, look, go destroy public installations and do anything else, but not kill innocent people. And for that, he apologized before the court.
That's what I'm saying. If the prosecution is accusing him of having abetted or having, if he's an accomplice in that conduct that he's accused of, and he's saying they did it, it is his means of defense. He's simply saying, I understand these things happened, they are unfortunate, but I did not ask them to do those. So he is actually not admitting. He's simply saying that these things, however unfortunate they are, which I agree they are unfortunate because there was a loss of innocent lives, I'm not responsible because I never asked them to. So he's trying to explain his refusal of being responsible. So that is not a plea. If he was pleading, he would clearly admit to the crimes he's been accused of and then cooperate with the investigation and the prosecution to give full information how those crimes were committed. Then it would be in the powers of the prosecution to decide whether that cooperation is good enough for them to seek lenience before the court. It doesn't take away the responsibility, but then the prosecution, given the cooperation, because it saves when someone pleads guilty, it saves public resources to prosecute that person. And it helps in getting some more evidence that the prosecution probably did not have. So that in itself is good. So the prosecution in its own discretion might decide, or in a negotiation with the accused, they might say, okay, now we're going to strike a balance. We will, if you agree to plead to these charges, we are going to request for a lesser sentence punishment than what you would normally receive. So you get the minimum instead of getting the maximum. But I doubt whether he really pleaded. I needed to know that he indeed pleaded guilty.
He just apologized and he was feeling sorry. Anyhow, Dr. Muleefu, many thanks for your timing again.
Thank you so much.
Dr. Muleefu is a senior lecturer of law at the University of Rwanda. Many thanks indeed.